Happy Christmas! Along with a lot of problems in the Renters' Rights Act, there's also some nice presents for landlords. So today, being Christmas Day, we're going to open those presents. So the first one we've got here, let me see what's in here. Oh, look at that. It's longer notice periods. Instead of tenants being required to give 1 month's notice, under the Renters' Rights Act, they'll have to give you 2 months' notice. That's a definite win for landlords. I wonder what else they've in there. Oh, another one here. Let's see what this one is. Okay, the next one, look at that. That's ground 2. Ground 2 was always a problem. That's the mortgage lender ground. And if you ever wanted to remortgage, you had to evict the tenant because the law said they could only use ground 2 if the tenancy existed after the mortgage had been granted. So for any existing tenant, they couldn't remortgage. It also made it difficult to sell a property with a tenant in situ. So this is a definite improvement for us. Wonder what else we've got. Oh, that's a nice big one. Wonder what. Excellent. They've given us a ground to sell the property. So if we want to sell, we don't have to serve Section 21 before the Renters' Rights Act goes live. We can just wait until the law comes in, and then we can use ground 1A. There's a bit of a process to follow, but at least we can be sure we can still serve notice on that ground. What shall I open next? That's a nice little gold striped one. Oh, look at that. Yeah, this is an interesting one because this is ground 7A. Ground 7A is one of 2 grounds for antisocial behaviour. It was always a bit odd that the mandatory ground 7A, where somebody had a conviction, required you to give them 1 month's notice, whereas ground 14, which was discretionary, didn't require you to give them any notice period at all. You had to give them a notice, but you could immediately go to court the same day. Now, you don't have to wait any length of period of time for ground 7A either. You can serve notice and go straight to court the same day. This is turning out to be a wonderful Christmas morning. Oh, this is a nice big one. Oh yes, look at that. The first 5 grounds under the Housing Act 88 required a landlord to give what was called prior notice. It meant that before he could rely on that ground, he had to have warned the tenant before they started the tenancy that they might seek possession on that ground. Now they've generally dropped those requirements for ground 1, the new 1A, and ground 2. They are no longer prior notice grounds, so if we don't serve notice beforehand, it won't stop us getting possession. What have we got here? Oh, another pretty wrapped one. Ah, yes, of course, retaliatory eviction. What a joke and fun present this one is. When they introduced retaliatory eviction, it said if tenants complained about the condition of the property and the landlord served Section 21, then that was retaliatory eviction. Well, of course, there is no Section 21, but in fact, they've gone further. They haven't just changed Section 21 to Section 8. They've actually got rid of the whole retaliatory eviction process. To me, that sounds like they found that it really wasn't working at all, so they've scrapped it, which is just another win for landlords. Oh, that's a big one we got last. Ah, yes. Do you know they've actually made it better for deposit compliance? The rules for deposit protection today say that if you do not protect the deposit within 30 days of receipt, you can never serve a Section 21 notice unless you give the deposit back to the tenant. Under the new rules that will come in with the Renters' Rights Act, you won't have to refund. You will not be able to get possession if you haven't done deposit protection. That's still true, with the exception of antisocial behaviour grounds. But for any other ground, you won't be able to get possession, but instead of having to refund it, you'll be able to seek possession under Section 8, provided you have protected the deposit even though you protect it late. So that additional penalty of no notice is gone. You'll still be liable to a potential penalty for not protecting it in time, but at least you'll be able to seek possession without having to refund the deposit. And that means you'll still be holding the deposit to be able to use it for damages or rent arrears. See, Renters' Rights Act, not all bad news. It's really been quite a Merry Christmas. Thank you. If you like this video, why not share, like or subscribe to this channel for further useful, helpful information.